Procedural due process. This serves as a restriction on actions of judicial and quasi-judicial agencies of the government. It has four requisites. First requisite, an impartial tribunal or court clothed with judicial power to hear and determine the matter before it. In Javier versus Comelec, there was a denial of due process when the Commissioner Opinion, who was formerly a law partner of respondent Pacificador, obstinately insisted in participating in the case, thus denying the petitioner the cold neutrality of an impartial judge. In Galman versus Sandigan Bayan, the court held that the people was denied due process, which required an impartial tribunal and an unbiased prosecution. In Tabuena versus Sandigan Bayan, reiterated in Imelda Romualdez Marcos versus Sandigan Bayan, the court held that when the court cross-examined the accused and the witness, it acted with overzealousness, assuming the role of both the magistrate and advocate, and thus denied the accused due process of law. The Supreme Court also reiterated the rule that a public officer who decided a case should not be the same person to decide it on appeal because he cannot be an impartial judge. In GSIS versus Court of Appeals, the police officer inspector who made an earlier recommendation that the application for death benefits be approved was held to be biased and should have inhibited himself from the proceedings. But in People versus Hereda, reiterated in People versus Medellina, even as the transcript of stenographer notes shows that the trial court intensively questioned the witnesses, approximately 43% of the questions asked of the prosecution witnesses and the accused were propounded by the judge, the Supreme Court held that the questioning was necessary. The judge have as much interest as counsel in the orderly and expeditious presentation of evidence and have the duty to ask questions that would elicit the facts on the issues involved, clarify ambiguous remarks by the witnesses, and address points overlooked by the counsel. In People versus Adora, the judge should be given reasonable leeway in directing questions to the witnesses in order to elicit relevant facts. It is expedient to allow the judge to question a witness so that his judgment may rest upon a full and clear understanding of the facts. In People versus Castillo, Cosep versus People, and People versus Galeno, the Supreme Court said that questions which merely clear up dubious points and elicit relevant evidence are within the prerogative of the judge to ask. In People versus Larrañaga, the Supreme Court said that the test is whether the intervention of the judge tends to prevent the proper presentation of the case or the ascertainment of the truth in the matter where he interposes his questions or comments. When the judge remarked that the testimonies of two witnesses were incredible, that another witness was totally confused and appeared to be mentally imbalanced, and the two witnesses were liars, his comments were just honest observations intended to warn the witnesses to be candid to the court. He merely wanted to ascertain the veracity of their contradictory statements. In Cruz versus Civil Service Commission, the court rejected petitioners' contention that they were denied due process, ostensibly because the Civil Service Commission acted as an investigator, complainant, prosecutor, and judge. The Civil Service Commission is mandated to hear and decide administrative cases instituted by it or instituted before it, directly or on appeal. Neither can it be denied that petitioners were formally charged after a prima facie case for dishonesty was found to exist. They were properly informed of the charges, they submitted an answer, and were given opportunity to defend themselves. In Tejano versus Ombudsman, the petitioner attributed the partiality to Ombudsman Desierto for having participated in the investigation of the instant case despite his having earlier participated in the initial preliminary investigation of the same when he was a special prosecutor. The Supreme Court agreed with the petitioner, saying that it is a steadfast rule that the officer who reviews a case on appeal should not be the same person whose decision is under review. Second requisite of procedural due process, jurisdiction must be lawfully acquired over the person of the defendant and over the property, which is the subject matter of the proceeding. It should be emphasized that the service of summons is not only required to give the court jurisdiction over the person of the defendant, but also to afford the latter the opportunity to be heard on the claim made against him. Thus, compliance with the rules and regulations The service of summons is as much an issue of due process as of jurisdiction. From the case of Sarmiento versus Raon, while jurisdiction over the person of the defendant can be acquired by the service of summons, it can also be acquired by voluntary appearance before the court, which includes submission of pleadings in compliance with the order of the court or tribunal. Third requisite, the defendant must be given an opportunity to be heard. Due process is satisfied as long as the party is accorded the opportunity to be heard. If it is not availed of, it is deemed waived or forfeited without violating the constitutional guarantee. In the case of Bautista versus Court of Appeals. In Enot versus IAC EO 626A was declared violative of due process because the owner of the carabaos confiscated is denied the right to be heard in his defense and immediately condemned and punished. In Eastern Broadcasting versus Duns, the closure of radio station DYRE, where the order was issued summarily without a hearing, was deemed violative of due process. In Tatad versus Sandigan Bayan, it was held that the unreasonable delay in the termination of preliminary investigation by the Tanad Bayan violated the guarantee of due process. In Gonzales versus Civil Service Commission, there was deemed a denial of due process, where the notice to the petitioner to report back to work within 5 days, otherwise he would be dropped from the rolls, was sent to the petitioner's Quezon City address, where the office knew where petitioner was temporarily residing in San Jose, California. In Lim versus Court of Appeals, the Supreme Court said that the closure of bistro violated the due process clause. Instead of arbitrarily closing down the establishment's business operations, Mayor Lim should have given bistro an opportunity to rebut the allegations that it violated the conditions of its license. In Unicraft Industries versus CA, it states that even as it is conceded that the decisions of voluntary arbitrators are generally accorded finality, whereas in this case the petitioner was not given a chance to present evidence, there is a violation of due process clause, and the arbitrator's decision is null and void. Knowledge of sufficiency of funds in or credit with the bank is presumed from the act of making, drawing, issuing a check payment which is refused by the drawing bank for insufficiency of funds when presented within 90 days from the date of issue. But this presumption does not hold when the maker or drawer bank pays or makes arrangements for the payment of the check within 5 banking days after receiving notice that such check had been dishonored. Thus, it is essential for the maker or the drawer to be notified of the dishonor of the check so he can pay the value thereof and make arrangements for its payment within the period prescribed by law. Absent such notice of dishonor, the maker or the drawer cannot be convicted of violating BP 22, as there would be a violation of due or procedural due process. Not all cases require the trial type hearing. Due process in labor cases before a labor arbiter is satisfied by the parties, or when the parties are given the opportunity to submit their position papers to which they are supposed to attach all the supporting documents or documentary evidence that would support their respective claims. Thus, there is no denial of due process where the Dole Regional Director decided the case on the basis only of position papers submitted by the parties. From the case of Valladolid versus Incheon. Indeed, the NLRC and labor arbiter are authorized to decide a case on the basis of position papers and documents submitted. The holding of an adversarial trial depends on the discretion of the labor arbiter, and the parties cannot demand it as a matter of right. Fernandez versus NLRC, Vinta Maritime versus NLRC. Likewise, in Torres versus Gonzales, the Supreme Court said that Section 64 of the Revised Administrative Code is not repugnant to the Due Process Clause, and the accused is not constitutionally entitled to another judicial determination of whether he breached the condition of his pardon. In Saldivar versus Sandigan Bayan, the Supreme Court declared that to be heard does not only mean verbal arguments in court. One may be heard through pleadings, where opportunity to be heard, whether through oral arguments or pleadings, is accorded, there is no denial of procedural due process. Neither is the respondent entitled to notice and hearing during the evaluation stage of the extradition process. PD 1069 affords the extraditee sufficient opportunity to meet evidence against him once the petition is filed in court. The time for the extraditee to know the basis of the request for extradition is merely moved to the filing in court of the formal petition for extradition. The extraditee's right to know is momentarily withheld during the evaluation stage to accommodate the more compelling interest of the state to prevent escape of the potential extraditees, which can be precipitated by premature information on the basis of the request for extradition. No less compelling at that stage of the extradition proceeding is the need to be more deferential to the judgment of a co-equal branch of the government, the executive, which has been endowed by our Constitution with greater rights over matters involving foreign relations. On the case of Secretary of Justice versus Judge Lantion. This was clarified by the government of the United States of America versus Judge Puruganan, where the Supreme Court said that upon receipt of a petition for extradition and its supporting document, the judge must study them and make, as soon as possible, a prima facie finding whether they are sufficient in form and substance, whether they comply with extradition treaty, and whether the person sought is extraditable. If no prima facie finding is possible, the petition may be dismissed at the discretion of the judge. On the other hand, if there is prima facie finding, the judge must immediately issue a warrant for the arrest of the extraditee, who is at the same time summoned to answer the petition and answer at the scheduled summary hearings. Prior to the issuance of the warrant, the judge must not inform or notify the potential extraditee of the pendency of the petition, lest the latter be given the opportunity to escape and frustrate the findings. Thus also the grant by the judge of bail was deemed null and void, as persons to be extradited are presumed to be flight risks. According to the resolution on a motion for reconsideration, the Supreme Court denied with finality Mark Jimenez's motion, saying that extradition is sui generis and does not fall within the ambit of the right to bail. The ruling in Puruganan was modified in Government of Hong Kong versus Honorable Felix Berto Olalia, where the Supreme Court said that it cannot ignore the modern trend in public international law, which places primacy on the worth of the individual person and sanctity of human rights. While the Universal Declaration of Human Rights is not a treaty, the principles contained therein are now recognized as customarily binding upon the members of the international community. In Medjoff versus Director of Prisons, this court, in granting bail to a prospective deportee, held that under the Constitution, the principles set forth in the Declaration are part of the law of the land. If bail can be granted in deportation cases, considering that the Universal Declaration of Human Rights applies to deportation cases, there is no reason why it cannot be invoked in extradition cases. After all, both are administrative proceedings where the innocence or guilt of the person detained is not an issue. Citing Chief Justice Puno's separate opinion in Puruganan, the court in Government of Hong Kong adopted a new standard to be used in granting bail in extradition cases, denominated clear and convincing evidence. As Chief Justice Puno explained, this standard should be lower than proof beyond reasonable doubt, but higher than preponderance of evidence. The potential extraditee must prove by clear and convincing evidence that he is not a flight risk and will abide with all the orders and processes of extradition court for entitlement to bail. In Rojas versus Vasquez, it was held that lack of notice to or participation of petitioner who had been declared by the Ombudsman in its original solution at the reinvestigation does not render the subsequent resolution on reinvestigation null and void, even if subsequent resolution reinstated the complaint against them. But in the resolution dated May 29, 2002, on motion for reconsideration in the said case, the Supreme Court said that the petitioners were denied due process when the special investigator reinstated the complaint against the petitioners without their knowledge. At the very least, they should have been notified that the complaint against them had not yet been finally disposed of. They should have been appraised of their possible implications in the crime to enable them to meet any new accusations against them head on and to prepare for their defense. The right of a party to cross-examine witness against him in a civil case is an indispensable part of the due process. Ortegas versus Lufthansa. But in administrative proceedings, technical rules of procedure and evidence are not strictly applied, since nothing on record shows that the petitioner asked for cross-examination. He cannot argue that he has been deprived of due process merely because no cross-examination took place. Likewise, it was held that where the petitioner were amply afforded the opportunity to register objections to respondent's offer of evidence, there was no denial of due process. From the case of Rodson Philippines Incorporated versus CA. The filing of a motion for reconsideration cures the defect of the absence of hearing. From the case of Chua versus Court of Appeals, the essence of due process in administrative proceedings is an opportunity to explain one's side or an opportunity to seek reconsideration of the action or ruling. In Quintos versus Comelec, it was held that the petitioner was not denied due process because he subsequently filed a motion for reconsideration which the Comelec considered and acted upon, albeit unfavorably. In Villarreal versus Fernando, it was held that there was no denial of due process where the appellee court dismissed the petitioner's appeal for failure of the Office of the Solicitor General to file the required memorandum. As a rule, the negligence of the counsel binds the client. Moreover, the petitioner in this case is not entirely blameless for the dismissal of his appeal. After the OSG's failure to file the answer to the petition for mandamus and damages, and to have the order declaring the petitioner in default lifted, the petitioner should have already replaced the OSG with another lawyer. The same principle was reiterated in Bromeo Brothers Estate versus Garcia. There are cases in which notice and hearing may be dispensed with without violating due process. Among these are the cancellation of the passport of a person sought for the commission of a crime, the preventive suspension of a civil servant facing administrative charges, the distraint of property for tax delinquency, the padlocking of restaurants found unsanitary, or of theaters showing obscene movies, the abatement of nuisances per se, and in Equitable Banking Corporation versus Calderon, the Supreme Court ruled that no malice or bad faith attended the bank's dishonor of Calderon's credit card, inasmuch as the dishonor was justified under the credit card agreement, which provided that the cardholder agreed not to exceed his approved credit limit, otherwise the card privilege would be automatically suspended without notice to the cardholder. A person who is not impleaded in a complaint cannot be bound by the decision rendered therein, for no man shall be affected by a proceeding in which he is a stranger. In this case, the respondent is adversely affected by such judgment, as he was a subsequent purchaser of the subject property, and title was already transferred to him. It will be the height of inequality to allow the petitioner's title to be nullified without the respondent being given the opportunity to present any evidence in support of his ostensible ownership of the property. It is tantamount to a violation of the constitutional guarantee that no person shall be deprived of property without due process of law. From the case of National Housing Authority versus Evangelista. Fourth requisite, judgment must be rendered upon lawful hearing. This is necessary because otherwise the right to hearing would be rendered meaningless. Relate this to Section 14, Article 8, which provides that no decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. Due process demands that the parties to a litigation be informed how the case was decided, with an explanation of the factual and legal reasons that lead to the conclusions of the court. From the case of Insular Life Assurance Corporation versus Young. In Lorbes versus Court of Appeals, it was held that courts should be liberal in setting aside orders of default because judgments of default are frowned upon unless in cases where it clearly appears that the reopening of the case is intended for delay. Where the order of default is immoderate, there is a violation of due process. Publication as part of due process. In Tañada versus Tovera, the court held that publication is imperative to the validity of laws, presidential decrees and executive orders, administrative rules and regulations, and is an indispensable part of due process. Thus, in Republic versus Express Telecommunications, the National Telecommunications Commission, in granting Bayantel the provisional authority to operate and applied the 1987 Rules of Practice and Procedure and not the 1993 revised rules because the latter had not yet been published, although the same had already been filed with the National Administrative Register. Appeal and due process. Appeal is not a natural right, nor is it part of due process. Generally, it may be allowed or be denied by the legislature in its discretion, where the Constitution gives a person the right to appeal. Example, in cases coming under the minimum appellate jurisdiction of the Supreme Court, the denial of the right to appeal constitutes there is a statutory grant of the right to appeal. The denial of that remedy also constitutes a denial of due process. In Alba versus Netodreda, Supreme Court reiterated that the right to appeal is not a natural right nor a part of due process. It is merely a statutory privilege and may be exercised only in the manner and in accordance with the provisions of law. Accordingly, the constitutional requirement of due process may be satisfied notwithstanding the denial of the right to appeal, because the essence of due process is simply the opportunity to be heard and to present evidence in support of one's case. In Barata versus Abalos, it was held that failure to provide the complainant the right to appeal in certain cases, example from the decisions of the Ombudsman, is not a denial of due process. It may be noted that in appropriate cases involving oppressive or arbitrary action, the complainant is not deprived of legal recourse by certiorari under Rule 65 of the Rules of Court, which applies suppletorily to the Rules of Procedure of the Ombudsman. In Sahot versus CA, it was held that there is no denial of due process where the court denied the appeal due to the negligence of the accused and his counsel. An appellant must strictly comply with the rules inasmuch as appeal is purely a statutory right.